Karis, if you're watching it on YouTube as well, you need to mute YouTube, otherwise we'll get, because me and Will always do it. You get like a feedback loop.
Oh
So we've
yeah.
run around that now. But because if you've got the if you go on the channel, which you get notification, and then you can see what people are saying.
Oh, I haven't got it up. One day I'm not having it on.
Here we go. Cool. Right.
Oh yeah.
Yeah. So it's good. Yeah. Cool. All right, guys. Welcome. Just let us get our audio sorted out for a second. Welcome everyone. Hope your week's been all right. Let me sort this out as well. Just bear with me. Yeah. Cool. Right. So and let me just put some stuff into the usual blurb in the chat. So yeah. For those who've been here before, you know what we're doing. Just going through questions that have come in either through the week on the YouTube channel or that are asked live in the chat. So if you're in the chat, say hello. We'll say hello back. We've got like 5 or 6 questions. We do the anonymized ones first. So I guess that's what I always say is if you're asking questions, ask it as if it's about a hypothetical person, rather than having to share your own data onto the internet. So you can get the same answer. In fact, you'll often get a better answer. And if someone puts personal data into the live chat, I'll just ask them to rephrase it and start again. It's not legal advice. You may notice there's 4 of us this week, so we're saying hello to Karis for the first time. Karis if she wants to talk about herself a little bit, she's a newly qualified solicitor, but she's kind of got a lot of experience, which I think is going to be really helpful for us tonight. So, and we might end up being able to do more of these or something if we get more people. So it's just nice to have 4 of us rather than 3. And we welcome back Will and Shannon. I got a message last week saying, "Oh, we really miss Will and Shannon." So welcome back, guys. Other bits and pieces, no, not legal advice, no personal data. I think that's all I've got to say, isn't it? I think that's it. I know Shannon, you're just talking about a case which Will then said, "Oh, that's my case." So I don't know, Will or Shannon, do you want to do it? Do you want to talk about it a bit? So just a bit of we got it to come through on Nearly Legal. So if you're watching and you're not subscribed to the Nearly Legal blog, I guess it is. It's by a really cool solicitor called Giles Peaker, who just kind of unpicks really kind of complex cases. A lot of it's kind of case law, which I don't care about, so stuff like leases and stuff, but it's really good stuff on things that we do care about, like homes applications. And if you go on his website as well, there's like a good archive of different cases. So Shannon kind of mentioned it, but yeah, Will, do you want to talk about it? So it was a suitability of temporary accommodation case, but there was something about it that's quite unusual. So do you want to say a
Yeah,
little bit?
stop me if I go on for too long, but it concerned a family that were intentionally homeless. So it was about a subject which is one of my sort of pet subjects, which is the sort of safety net that you've got after you're intentionally homeless. Because on the face of it, if you are intentionally homeless, even if you've got kids, you get a letter saying, "Well, we've discharged our duties. We don't owe you any duty. We're going to cancel your temporary accommodation." It can be the same if you refuse an offer of accommodation as well. So, and traditionally, the position was that you'd then say, "Oh, well, Children's Services will have to help under Section 17 of the Children Act." But then Section 190 says that they have to provide assistance in obtaining, a bit like the relief duty, they've got to provide you with assistance in finding accommodation which is suitable for you. Not the same as a full duty. So the question is, on the one hand, if that duty to provide accommodation is a really strong duty, there's no point in making people intentionally homeless, because if they've got kids, you've got to house them anyway. And on the other hand, if the duty is so weak, then it flies in the face of providing second safety net, as it were. So it's something I've always wanted to test. And in this case, what the council did was they said, "Okay, this is in Bexley, by the way, which is, for those of you who don't know, is southeast London, just on the outskirts of London." And the council said, "Okay, we'll stick you we'll put you in a hostel in Manchester for 2 weeks." And that was also in discharge of the Children Act duty. And we said that can't be, and they hadn't done any assessment, and the 2 children had special needs. And so we judicially reviewed that. Unfortunately, it took like a year or something to get to a full hearing, during which time we didn't get interim relief. But at the end of it, they said, "Yes, you've got to go back and do it again." Although the council did come back with a letter saying, "Well, we're not going to give you anything, and you can challenge it if you want." So we were about to go back. But then we were supposed to have a 204 appeal on Wednesday this week, which was what, yesterday, for the main, to challenge the intentional homelessness bit. And we were pretty sure we were going to win that. But then last Friday, the client rang me and said they'd managed to find a private place. They just needed the rent in advance and deposit from the council. So I said to the council, do you want to pay this money, or do you want to go to court and be at risk of paying inter partes legal costs if you lose? So even though they'd said, no, we're not going to help you, they came up with 3,500, paid them, and now they've got a nice place to live. But we never got to challenge the intentional homelessness, but it all turned out well. But it's an interesting, it hasn't really solved the question of just how big is the duty to give families Section 190 assistance and Section 17 support. But this shows that it's real and you can't just sort of ignore it. You will get into trouble. So that's my summary.
Yeah, that's really cool. Yeah, I mean, I didn't quite realize how much there was to that. So yeah, it's good. Well, yeah, well done for getting that far, really, and for getting a good outcome. Hey, what, Ramela? So any other gossip for anyone? If not, oh yeah, go on, Shannon. You seem cool.
Yeah, so just a couple of things from me, I guess. It's not really gossip, but the Housing Ombudsman has got a call for evidence out at the minute. Repairing trust, so it's all about disrepairs and repairs. So yeah, if you are a tenant or a client, or you've had to go through the repair system, take a look on the Housing Ombudsman, get your feedback in. I'm sure ask lots of different questions. But those things do make a difference. And then, so Expert Link, which, full disclosure, I work for Expert Link, but they've got an opportunity coming up for either people who have been on Mapper or staff who have worked with those on Mapper, under Mapper, to give their feedback to the DWP about how it is as a client, because they want to improve services for those who are subject to Mapper. So if you're interested, yeah, either pop it, if you email info@expertlink.org.uk, and then you can get all the information. But yeah, I just wanted to highlight those two sort of opportunities and stuff coming up.
That's cool. And yeah, and Expert Link do look after people as they kind of, yeah, so it's not you just don't get thrown into a meeting with DWP. You kind of do some prep work and kind of
No,
go in.
Yeah, so just to clarify, it's with Expert Link for the DWP, and we don't need to know any of your history. We're not interested in sort of not interested. That sounds awful. Okay, we're not interested at this moment in your like journey through the criminal justice system. Just interactions with like the job centre and stuff. So yeah.
Cool. All right. Okay. Right. Let's get into the questions. So someone's put a question already, which is a decent question. Let's just do that first. Let me just get it up and running. So it's quite a quick one, basically. And I think you probably guess what we're going to say. So hold on, let me just get the screens all sorted out. Nearly there. Cool. So that's the one I want. So Shannon, let me know if you can't see the right one now. Just collapse that as well, make it a bit tidier. So it's not right that to present as homeless, a person has to be ready outside for 3 visits a week at any time during the day. Homeless people might sofa surf or go through the wash. Yeah, so I mean, so basically some councils, I mean, Will's talked about this maybe a couple of months ago now, where councils just make it harder and harder to approach in person. So as in, like, they won't have an office at all, and they kind of say, oh, you need to come to the library. Move the camera, sorry guys. So basically, you don't need to approach in person at all legally. So, and I'd say you don't want to approach in person if you can help it. So basically, I did a video on the channel a little while ago, which was the best way to make a homeless application. And effectively, you do everything via email. So there's no requirement to be at a certain place at a certain time. Same would go with kind of verification if you're rough sleeping, something like that. So yeah, so you might be sofa surfing, you're legally homeless. You need to go through the process, as the video suggested. It's quite methodical, and it seems like a lot of work. But basically, I think if you don't follow those steps, you can kind of leave yourself open to just getting forgotten about or getting a bad decision down the line. So it's worth kind of just looking at that, I'd say. So hopefully that answers that question. Anyone else wants to come in on that, just let me know. Or if I misunderstood the question, you think. If not, I'll get on to the next question that we've got coming up. So here we go. Next question. So someone that I know is unintentionally homeless with complex mental health issues, I guess. They have applied to the local council, but I actually don't want to live in that area. So it's about, okay, personal data a little bit there. But anyway, so is there any way that they can request to move to a different borough? Bear in mind, they haven't even been offered anywhere yet and they're still in relief duty. So let's just deal with that part of the question first, because there's some other good questions that kind of come out of this as well. So if you're still in relief duty, if someone is still in relief duty, there is that potential to kind of be flexible. Now, local connection does apply. I mean, you might have heard me say if you watched the stream before that local connection isn't kind of what everyone says it is. You know, it's not a reason for a council not to start the process. And people can have multiple local connections, or they can have no local connection to anywhere at all. They might have local connection somewhere, but it's unsafe for them to be there. So there's kind of a lot of things that kind of come in with local connection. But what you probably can't do, well, what you definitely can't do, let me say that again, just to be pedantic. It's very difficult to approach a council where you don't have a local connection there. So let's say you approach council A, you don't have a connection to council A, but you do have a connection to council B, which is somewhere else, and it's safe for you to be there. Councils would be within their rights to essentially, what they should do is accept the application, do the assessment, get the personalised housing plan done, but then use the Section 198 mechanism to refer you back to council B. Now they don't have to do that, which is why I'm saying I'm being a bit pedantic here. But they don't. There's no requirement for councils to use local connection at all. It's just discretionary in effect. But because they're protecting their resources, they basically will do. So in a situation like this, what you'd need is ideally you'd want another area where you do want to live, where you do have a local connection. So let's say you've lived in one area for the last 3 years, but you've got close family living in another area. You would have local connection to both of those areas. What you would potentially be able to do, and you want to discuss it with your housing officer, because your housing point would be very, very keen to help out, because it basically means that potentially they might be able to get rid of you, basically. So have a conversation with them. You're in relief duty. They should be kind of doing the whole personalised housing plan anyway, and basically ask them, tell them about your situation and ask them, can I withdraw my application here and approach a different council? And that would be possible. But you can't do it if you don't have a local connection to another area and you do have a local connection to this council, because all that's going to happen is you're going to most likely get referred back here, even if they do accept the application. So that's my first stab at an answer to that first part of the question. You guys, you've got anything to add to that or take away from that?
Just one small thing, I guess, because I think Bedford had it for a while. I don't know if they still do with Luton, where actually, so even if you don't have local connection, it's still worth that conversation with the housing officer, because some councils have like a deal essentially where they swap tenants and clients and stuff. Not every area will have that, but it's still worth that conversation even if you don't have a local connection to another area, because you don't know what's sort of going on behind the scenes for local authorities to sort of be easing the stock for others or whatever it might be.
I mean, that the one of the reasons a council would have a reciprocal arrangement with another council is that within the code of guidance it talks about, for example, people who have previously had maybe drug and alcohol issues and they want to get away from an area because of the associations there. And so Bedford would use the kind of reciprocal arrangement with Luton, where they basically trade someone. So they send someone to Luton, someone from Luton would come to Bedford. But potentially as well, you might have a situation where where this council A, let's call it, there's nothing stopping them actually helping you into accommodation in another area. And again, actually, that for their purposes, that helps them out because they're getting someone out of their area, they're getting someone over the parish boundary. So that might also be, again, it just comes back to having that conversation with the housing officer, and any sensible housing officer will be quick to have that conversation. So I know we talk a lot about housing officers just basically ghosting people and kind of blanking them, but in this situation, it would certainly be worth a housing officer having that conversation with you. So anything else on that question? That's the first part anyway. So if we just go a little bit further, so also when they contact their local council, is there anything in particular they should say? Should they just update them on the situation and ask for advice, as well as copy them into emails? So this is something we often say in the live stream. If you're in a situation like this, you want to involve local politicians. There's nothing to lose by doing so, other than potentially waste a bit of time if the councillors are rubbish. But basically, I would say what you're looking to do is really explain your situation to the counsellor, because part of their job is to help their constituents out, and you basically involve them in your case, so that when you're emailing the council questions or whatever, if you're copying in the counsellor themselves, the housing officer is much more likely to take it seriously, because they get chased if they don't respond to it. So other than that, it kind of depends on what your situation is, if there are any particular complexities about it. But there's nothing wrong with just kind of approaching a counsellor, even when it's legally a simple case, because they can still help. They can still, as I say, chase council officers up, add a bit more pressure onto the council to actually respond properly, and just kind of be, I guess, increase the amount of accountability on that housing officer doing their job, which is not a bad thing. So again, I don't know if you guys have got anything else to add to that, but I think there's no kind of magic to it. You don't have to sort of say anything magic to kind of get the councillors involved. They should be interested in your case. If you're saying, look, I'm in a desperate situation, I'm homeless, they should be, in my experience, and it's certainly better for councillors, they'll generally be, they'll be pretty darn helpful, to be honest.
I've got one little point to make on that one, if I may. The maybe I'm clutching at straws, but it says that if you don't want to live in the area, it depends on what your reason for not wanting to live in the area is. If you might be at risk of violence or abuse, domestic abuse in the area, then you can apply to any other authority you want to, even though you don't have a local connection with them, if you'd be at risk of those things in the area where you have a local connection. But I'm assuming that you only said you don't want to live there, that's perhaps it's just a question of preference rather than being at risk.
Yeah, cool. I'm just multitasking, so yeah, I assume what you just said is great. Well, didn't actually hear it, but yeah, cool. There's just quite a long stream of questions there, just trying to work out if it's just a comment or if it's actually a question. So okay, on a sec, there's just a bit of personal data on there. I'm just going to try and just remove that briefly. Some of it's just kind of generic stuff. So yeah, I'll come back to that in the live chat. Just give me a sec for that, guys. So let's just go to, unless we've got anything else to say on this question here, question 2. If not, we'll go to question 3. Cool. So question 3 is, are family members allowed to be an impartial witness on your behalf? And I assume this is in a context of a homeless application. There's no reason why it wouldn't be. So as part of the council's inquiries, they will, they may want to talk to your family members. They need to, it depends why they need to speak to them. So let's say it involves domestic abuse, then they certainly, the council certainly can't A, approach the perpetrator, or B, do anything which is likely to kind of increase risk. And obviously family dynamics can be quite complicated. So council officers need to be very careful about approaching family members in some circumstances, but in other circumstances, the family member may well be of great help. I guess it's an interesting kind of idea of, can they be an impartial witness? Almost certainly it's going to be difficult for family members to be impartial, so I'm not quite sure how that kind of works, but they certainly can, kind of provide additional evidence to help you out, to kind of give the council more detail. Might be, it could be about confirming certain details or whatever. So yeah, I mean, certainly family members are allowed to be, I guess is probably the short answer. But I guess, I don't know if there are other situations which might change that or kind of add a different dynamic to it. I haven't seen it happen too many times in the cases I've been involved in, to be honest. Generally speaking, I'll be certainly as someone trying to support other people, I'll be trying to get professionals giving information, and generally speaking, I'm able to do that. It's not generally that hard, because I guess they're more likely to be impartial. I guess councils probably wary of kind of getting that partial evidence from family members potentially. I don't know. What do you guys think? Any situations you've been involved in at all?
I was involved in one just this week with something about local connection. That somebody said they had a sister that lived in the borough, but she wouldn't talk to the council, and I was saying, well, she does need to talk to the council, because otherwise they can't be satisfied that she is your sister and she lives in the borough, because so she'd need to be a witness of that, but that might not, I'm not quite sure what it is they'd be giving evidence of. But generally, I mean, family members can be witnesses, whether they're, I mean, normally it's difficult for family members to be impartial, isn't it? Because, like, to every mother, a goose is a swan. So, you know, but I think they take that into account.
Yeah.
Sorry, that's
Yeah.
a bit.
No, I get it. I get the reference.
Yeah.
Yeah. I think. I guess in one sense, I mean, to be kind of cynical, council officers will quite often not want to ask for any evidence which actually supports the applicant. So if they think they're going to, if they think they're going to get like something which is going to make it more difficult for them to discharge a duty to or end a duty to, then they're probably less likely to do it. But yeah, I guess in a local connection situation, I guess they'd want to know, are you actually related and how long have you lived in that borough, just to kind of satisfy the criteria of local connection. But yeah, as I say, there's no reason why they can't do it. But yeah, it'd be difficult to kind of to show that you're impartial, depending on what the situation's about. So I certainly I say that I have seen situations where family members have given supporting evidence that someone is a victim of domestic abuse, and that's been pretty straightforward, I guess. So yeah, cool. Anything else on that one, guys? If not, we'll go to, I think actually this yeah, so that is the end of our anonymized questions. So we'll go to the live chat now, and then we'll come back to do the other ones that have come in through the week. And I'm just trying to keep track of everything, so forgive me if I miss something. So first question I can see is, can a landlord be sued for disrepair after the issues have been resolved? And I don't know the answer to this, but Will and Caris, your solicitors, you might know the answer to this. Anyone want to have a stab at that one?
Should we have a go, Caris?
You shaking your head no?
I can if you want. But the answer is yes. Because you could sue for, let's say, for instance, you because of the disrepair, or various belongings had to be thrown away, or you'd suffered loss of enjoyment of your home, or worse, you'd suffered some form of injury, you know, say the ceiling fell in on your head or something. You could sue for all of those things, and you'd be claiming compensation rather than an order requiring them to carry out repair works. The bad thing, though, is that legal aid isn't available for that. So you would have to either enter into what's called a no-win, no-fee arrangement with a lawyer, which quite a lot of lawyers are keen to do, and you would then not pay them. They wouldn't get paid if they didn't win, and you wouldn't have to pay, although you might be at risk of paying the other side's costs if you lose. But maybe that's going too far down the rabbit hole. But yeah, you can. The answer is yes, you can sue. They can be sued.
And so in terms of someone's in that situation, are there going to be certain solicitor firms that are more likely to take those cases on? Is there any kind of like database that people can, because I remember I've tried to get solicitors involved about certain issues, and it's quite difficult often to find a solicitor's firm that has the speciality that you want. So I'm thinking of a historic sexual abuse claim that I'll kind of help someone out with. So but it's quite difficult to find a solicitor that kind of met that remit. Although we got lucky in the end, but yeah.
There's a lot that will do it. I'm just seeing that there's a lot of people in the legal profession look down on them as sort of claims farmers or the housing equivalent of ambulance chasers. So if you here's a good example. If you Google sue landlord for disrepair, the first thing that comes up is, and I'm not in any way saying anything negative about this, but there's an organization called the National Claims Centre, and they say, no win, no fee solicitors, make free claim inquiry in 30 seconds. So you can see they're quite keen to take the case on. I couldn't say, and then there's a few others down there as well that are doing that. And they're keen because they've got a factory going, so they can basically take action against the landlord, get their costs. What they're not good at is getting orders requiring landlords to carry out repairs, but you can get that on legal aid. So yeah, I hope that answers that.
In your opinion, without trying to stitch you up or anything, like, I mean, are those kind of have you broken your leg at work recently type solicitors? I mean, will they do a good job? I mean, as you say, they're specialists at getting you money, getting them money. But is that, I mean, would you recommend going to an organisation like that, or kind of a? The trouble is,
being a solicitor, I'm sort of not very keen on solicitors, and I know that there are a lot of cowboys out there. And so I would never really feel comfortable recommending anyone to go to a firm of solicitors if I didn't know them. personally, because the danger is you get a lot of people that they'll employ paralegals who have no qualifications at all, put them in a suit, get them to put in a posh accent and pretend to be a lawyer. And then you can, find out the hard way that they don't know what they're doing. I'm not saying that's what these firms are doing. I suspect that with disrepair, it is quite straightforward. And if you go to one of these firms that specializes in it, they may be a bit quick to settle once they think they're going to get their costs. But they'll probably do as good as, the odds are they'd probably be all right. It's not that bad. I haven't heard too many horror stories about it. The big problem is they tend to leave people. They'll get some money, but then they'll leave the people without getting the repairs done, which is where people contact me. But the person who's asked the question will probably be happy with that because the repairs are done and they get some money.
Yep.
So yeah, I mean, as with all lawyers, you don't know whether you're getting the best compensation that somebody else might have got. That's all I can say, really.
No, that's cool. That's helpful. Cool. Should we go to
We
the
can
next
add.
one?
Sorry.
Well, you're gone, Karis. Yeah, sorry.
Sorry, I was going to add the before lawyers are involved bit. You can put all your questions to them and say, well, this is what you've cost me, and could we have this compensation before you approach a solicitor in the first place?
And would the legal process really want people to have done that? Because I know some court processes want you to try to resolve everything you possibly can before you engage with a solicitor. Is that going to be likely how it is here?
Yeah, because they like parties to have tried to mediate and come to an agreement, and they always say court should be a last resort. So
Yeah.
in terms, if you've gone to them and said, okay, you have fixed this, but this and this was the damage, this is the invoice, these are the pictures, gathering that evidence for them, you can say to them, well, I now want this much for what you've cost me and this much in damages,
And
before you've approached the solicitor.
Is there like a doc? So within kind of stuff me and Shannon do. So there's like the LGO's got the guidance and remedies, so it kind of says how much to ask for, basically. What elements get what money. Is there anything equivalent to that where, so let's say bad damp and mold? Is there a document somewhere which says, what a bad damp and mold case would be £3,000 or something like that? Is there anything that helpful when you're asking the landlord for the for a suitable amount?
Sorry, I have loads of background and I couldn't hear anything you just said.
So just basically, with the kind of things Shannon does, we're talking about getting people compensation for gatekeeping and kind of that sort of thing. And we use the LGO's guidance and remedies document online. So that kind of gives us a ballpark. So we talked about it a few weeks ago, where if you're a family with children and you've been in the B&B for more than 6 weeks, then the LGO recommends £100 to £200 per week you're in. Is there anything similar to that for disrepair issues, which kind of give you a ballpark figure of what to ask for? How does the court calculate how much to give you? And if Karis, if you can't hear me, then feel free to come in on that one.
Yeah, there's I've got this book here. I don't know if it's backwards, and if I hold it up to the camera, it might come.
Put it in the middle.
Can you see it?
No, it's all blurred out, mate.
Sorry. It's called.
Fancy.
It's by Giles Peaker, by coincidence, along with Jan Luber, or Casey, who and Catherine O'Donnell, and they've written a book called Housing Conditions, Tenants' Rights, which is useful, and it's got a section about damages, but it doesn't answer your question. The simple answer to your question is, there's lots of legal authorities for what you can get, but the problem with disrepair is that no two cases are exactly the same. So it's not like, in personal injury cases, there's a book called, I think it's called Kemp and Kemp, and it's sort of, you can look up what it costs, what you're entitled to if you lose a leg in a road traffic accident or something, which again is really subjective, because if you're, it's very difficult to do. But the Legal Action magazine prints a lot of reports of judgments, and if you were going to court, you'd probably go along armed with various of these. But the bottom line is, there's two sorts of compensation. There's general damages, which is loss of enjoyment of your home, and then there's what's called special damages, which is to reimburse you for expenses. And general damages, what you do is you take a percentage figure So, for instance, if your home was completely uninhabitable and you couldn't live there, that would be like 100%. And you apply that figure to the rent, and then you say, well, I was living in this place for 6 months, and it was let's say in reality it would probably be, you're normally going 30 or 40%, because you say, I got water coming through the living room ceiling or something, I couldn't invite people round, and it was a miserable life. And so you'd say, I'm basically want 30% of my rent over that period. So you multiply the rent by the percentage, you multiply that by the figures, by the period of time, and you come up with a rough figure. Very crude assessment. And if you actually got to court and you had a barrister, they might go away and dig out some cases, which would say, in 1989, there was a case where somebody had damp in 2 rooms out of 4, and they got this much. But that's how you do it. And then you do. The other problem is, if I don't know if you're the same as me, but if for instance my home got flooded out or worse, and I lost all my belongings, I would have difficulty producing proof that I ever owned any of them, because I haven't got a sort of portfolio of all the receipts and things. And so a lot of landlords will say, well, you haven't got any proof you ever owned that. But if you go online and go to Amazon.com or something and say, well, I had something like this, a coat that looked like this. I mean, the judges can tell if you're taking the mickey, because there's a lot of people sort of suddenly find they had 5 MacBook Pros and sort of mink coat and stuff, which is not going to be believed. But if you make a list of all the things and you go along with proof of what they would cost to replace, the court will probably assess based on that. So it's best to just put the figures together and make a claim that way.
Okay. And in terms of that kind of attempting to mediate before you get a solicitor involved, so do you kind of give the best estimate you can when you put a price to the landlord? Because obviously the landlord's going to say, oh, I think it's 50 quid, and you're going to say, well, it's at whatever items I've got, it's 10,000 or something. I mean, have you got any kind of tips for kind of where to gauge that? And I'm asking the same sort of thing when you go into a council asking for compensation. I would say that I don't see any reason. Let's say you've got the family and children in B&B for more than 6 weeks. If the LGO recommends £100 to £200 a week, well, if I was in that situation, I'd ask for £200 a week, because I don't see any reason not to. But yeah, I guess I'm just thinking in terms of, for people who are kind of looking to do that, I'm sure it's a pretty common issue, whether how to kind of gauge that amount. I know you've given a bit of an answer there already, Will, but I'm just thinking,
it's really difficult.
Do they just kind of go low?
It's really difficult because people do get, I call it sort of litigation fever, or sort of Las Vegas syndrome, that they get dollars in their eyes very quickly, people who are making claims. So, and it is difficult because if, people are really angry. So I've got one at the moment. I've just sent some instructions off to a barrister, because the client has had about 2 years of problems, and they want £150,000. And I've said to them, there's no way you're going to get that. I mean, you might be lucky if you get 15 or 15 to 30. But all I can do is say, well, let's see what the barrister comes up with, and they'll go away and do some research. But you could ideally put together your list of stuff before you get a lawyer involved. But to be honest, most landlords, even sort of local authorities, I mean, private landlords are not going to say, oh, yeah, okay, then I'll give you sort of 10 grand. And local authorities have what I call a tadpole theory, which is that if they ignore everybody that makes a claim, probably only about 1 in 100 of them will actually get to court. So, and then they'll offer you, like you say, they'll offer you something stupid. But one thing to bear in mind is that the lawyer, if you go to a lawyer, they will probably put something together and do what's called a letter before action before they issue proceedings, because they know that they're not going to get their costs if the other side say, well, they ambushed us. If they'd sent us a letter, we would have paid this without going to court, which of course they wouldn't. But the judge will say, yes, you should have done that letter. I'm not going to give you any costs. So they'll do a pretty comprehensive job of that. And there is a thing called the pre-action protocol for disrepair proceedings, which you are supposed to follow, which I can go into detail about if you want, but you may not.
I wonder if we do that as say that's a separate video, because I think because I think it does sound interesting. But I mean, I've kind of used pre-action protocols before, and it's a bit of a elaborate.
It is something we should do. So I think we should do another video on, because there is so much disrepair at the moment. I mean, I'm just getting so many cases because of local authorities discharging their homeless duty by putting people in the private sector. it's almost the standard thing I'm having to do now is a standard letter before action on the disrepair, and then a request for a Section 202 review on the suitability because it's full of mould. So yeah, it's important.
Yeah, okay, that's cool. Well, we'll put that on the list, our long list of things to do. Nice one. Okay, so next question, unless we've got anything to go for that, is that all right? You got anything else to add to that, Karis? You all right? No, cool. So question 5, can the housing council turn away an applicant if they're in priority needs but have a job or regular income? So interesting question. Sorry, my pedantic nature's getting better at me there. So yeah, I guess a few kind of broad things to say about this. So I've seen councils say, oh, you've got a job, therefore you're not in priority need, but that's not the test. That's this. We've kind of talked at length about the test before, other times. So in one sense, it's relevant to whether or not it is a relevant issue. If you can hold on a job, then obviously that does say about certain things you can and can't do, but it in no way means that everyone with a job can't be in priority need. But I guess you've also potentially got the issue of affordability of temporary accommodation. And I think that's maybe what we're talking about here. I get we can kind of approach it from different angles as well. Because if you're earning a certain amount of money, then you're going to find you run into difficulty claiming housing benefit for temporary accommodation, because temporary accommodation generally will be ridiculously expensive, not all the time, but I guess, they kind of use private sector leasing companies, and it's just, you're paying well over the odds for what it's actually worth. And so I've certainly seen situations where a council will say, oh, you can't get housing benefit, therefore you're going to have to pay whatever, £2,000 a month or something to live here, a hotel or something like that. That again is not legal. When a council offers Section 108 interim accommodation or temporary accommodation, one of the key factors is it has to be affordable. And so what they'll essentially need to do is have a look at what your income is, how much housing benefit you are actually eligible for, and basically make it affordable. So I've talked before about a case which I was involved in a few years ago now, where a guy, he jointly owned his home, so he had massive assets, couldn't claim housing benefit, but the council still had a duty to provide temporary accommodation. So essentially they had to offer it at £1 a month so that it was therefore affordable for him. So the same thing would apply here. So if you've got a job you're earning and therefore you're not eligible for housing benefit or something, the council need to factor that in, and they need to make sure that, you might have to pay a good chunk towards the costs, but it's not the same thing as paying all of it and making it unaffordable. So I'm assuming that's what we're talking about here. So if for the person asking that question, if you want to clarify that, of you guys, have you got anything, Shannon, you got anything to add to that one?
I don't think this is the case, but on the off chance that because they've said housing and they've applied for a housing register and they've got a priority need in terms of banding on the housing register instead of priority need under Part 7, I don't think that is the case, but just in case it is, then yeah, potentially they could, depending on the local allocations policy. I don't know. I don't think I've ever seen one actually that sort of would make someone exempt from an allocations policy if you did have a job or regular income, but they can sell it themselves, can't they? So potentially, but I don't think that's what's happening here, but it's the words are often similar and get confused, don't they?
Yeah. I mean, so most housing allocation schemes that kind of define the housing register, wherever they possibly can, they'll prioritise people in work because social landlords want people in work. They're kind of, and I'm pretty sure there was some kind of pretty big cases some time ago which was shown that those kind of policies were unlawful because they discriminated against people who had disabilities and therefore couldn't work. So I think we're going back, sort of 7 or 8 years or so when that sort of stuff kicked in. So yeah, I think, I mean, again, just to kind of like approach it, just kind of read it again. So certain having a job has absolutely no bearing on your ability to make an application, whether it is under Part 7, as in the homeless application, or to the and to the housing register. Neither, it doesn't affect either of them. Plenty of homeless people have jobs, and plenty of people in priority need have jobs. So I guess the answer is no. But I'm not quite sure if we've maybe done justice to that question. So if, as I say, if that person wants to clarify that question again or whatever, and so we give a better answer, feel free.
This is a bit area dependent as well. Sorry, I just popped into my head, but it is really area dependent. And I don't know all the areas off the top of my head, but obviously there's sort of a link between people becoming homeless and losing their job, unsurprisingly, I guess. But in some areas, the local job centres have sort of like housing specific work coaches. So even though you are in work, it might still be worth a trip to the job centre to say, look, I'm homeless. This is sort of what's happening. I'm really worried I'm going to lose my job and I'm going to have to come to you guys and apply. And you'll be amazed at how helpful they will be in sort of contacting the council on your behalf. You know, they're subject to duty to refer, which I know comes with its issues if it's not actually making a homeless application. But it might just be another sort of avenue to that the council is going to struggle to ignore, if that makes sense. So yeah, it's a weird one because you're in work, so you wouldn't think to go to the job centre, but it might be worth a shot.
Yeah, cool. I was just checking to see if if the question's been clarified. I can't see anything on there. So I think that's, yeah, we'll kind of assume that's okay for the time being. So next question. Now there's a long string of text here, so I just need to work out where the question is. So it looks as though someone's quoting from a letter they've got, and as I say, I can't see the actual question. But basically, it's just, I mean, if nothing else, it's making the point that councils can discharge their duties into the private rented sector. So they can do that in the main housing duty stage. So, you know, once the application has kind of been decided on, then they can make a 12-month, an offer of a 12-month assured short-hold tenancy that's suitable. That would be a legitimate discharge of the main housing duty. They can also make what's called a final accommodation offer within the relief duty stage, which would only need to be a 6-month assured short-hold tenancy. And again, it would need to be suitable. So this kind of idea, you know, so Will talked about that case at the beginning of the live stream tonight about suitability being a really key issue. Any accommodation that's offered needs to be suitable. The only kind of thing that kind of is a bit elastic with that is that when councils put you somewhere in very short term, you know, so like, you know, over the weekend, that kind of thing, or in the short term, it doesn't need to be as nice as it would be if it was for longer term stuff. So I think, I don't know, yeah, guys, can you see a question? Have I missed something there? I did delete the bit with personal data in it, so it might be that the question was in there, but that person, if they want to rephrase that question to actually not include personal data.
The only place I could see a question mark was in the message, like council is say under section 193 7AA of the Localism Act 2011 question mark. But
okay,
I'm
yeah, I mean,
not
so
sure.
I'm pretty sure that was the Localism Act that enabled councils. So that's 2011. That was the one that enabled councils to use private rented accommodation as the discharges. So yeah, again, if that person wants to kind of just sorry, so apologies if we've made a hash of that, but I can't see the question really in it. But other than say, yeah, that's so there's, I guess there's still some people assume that you'll get social housing if you make a homeless application. That simply isn't the case. I don't know what proportion it really will depend on the council, you know, as to the likelihood of it. And certain things will increase or decrease the likelihood. So, for example, if you've got a mobility issue or something, that probably means it's more likely you'll get social housing. But again, there's no absolutes in that. So might be we come back to that person in a little bit and kind of continue on that strand. So next question that I can see. A bit off topic, but can you apply to work for a council if you're on the housing register on a homeless and living in temporary accommodation by the council? Friend is asking, so when you say applying for a job as a housing officer, where's my mouse cursor gone? So if I put that there, that kind of makes sense. So I think the answer is there's nothing stopping that happening, and I'm sure, you know, I've certainly worked with people who've been homeless and then they've gone on to be housing officers. I'm sure there would be kind of potential things they need to kind of bear in mind. So there would be, you know, similar to sort of thing when you apply to a housing register, you have to declare whether any of your friends work at the council, just to make sure there's no kind of your cousin or something kind of bumping you up the priority list or something. I know there's some Birmingham cases a few years ago where that happened, and some rogue housing officer was just basically dishing out social housing to their mates or their family, whatever. So I think the answer is, I think yes, you can do it, but I think the council would just have to kind of have that conversation about how they handle the fact that essentially your colleagues would have access to your highly sensitive data. If nothing else, that would need to be thought through. So yeah, I would say it's possible. You know, you don't need to have any qualifications to be a housing officer, as we've kind of lamented about before. So it's yeah, it's not ridiculous to kind of apply, but you obviously want to have that conversation with your employer just to see how they're going to manage that situation for you. So yeah, I think the answer is yes. Again, guys, if you've got anything to add to that, feel free. So if not, next question. Is a Section 21 valid if repairs were requested before it was received, but after the tenant knew it was going to be issued? Okay. It's like one of those IQ test things. I'm trying to work out what it's saying. So okay, so the letting agent is basically given the heads up that the Section 21 is going to be issued, is what I'm assuming here, and the tenant is then basically requested repairs. I thought there was some kind of like exemption period if that's the case, but I'm not confident with this at all. So again, if anyone else wants to have a go at answering that, feel free. Well,
I can answer that very briefly. The answer is that disrepair doesn't make any difference unless the council have served an improvement notice on the landlord in relation to the disrepair. Correct me if I'm wrong, please, anybody out there, but it's not enough that you've written to the landlord and said, I'm not happy about the conditions here, or the place could be in a terrible state. The question is whether the local authority have served the notice. Now, my recollection is the notice could be served before possession proceedings are issued, after the notice. I may be wrong about that, but basically don't think that basically if you've got disrepair and you're worried about a Section 21 notice, try and get the council to serve an improvement notice. It is pretty tricky because most councils have cut their environmental health departments to pieces over the last 20 years, so there's nobody there. And I've hardly ever seen an improvement notice being served, only once or twice. So I hope that answers it.
Can I ask a follow-up question? What sort of state does a place need to be in to get an improvement notice? Like, is there like a list of issues that you would tick the box for an improvement notice, or what are we talking?
Well, the Housing Act 2004 has a load of things called hazards in there, and those are what local authorities are really looking at to see whether they pose a threat to health and stuff. And again, I think there's a chapter on it in Giles Peaker's book, and it's something I keep meaning to get my head around, because it is quite a useful thing to know about when dealing with local authorities. But it's essentially it's in there. There's schedules of things like if the electricity's dangerous, or there's the different classes of hazards. So those are the sort of things they'll be looking at. But really, with disrepair, you're often talking about damp and mold and stuff, and that in itself is sufficient. So it's worth giving it a go, but you just got to be persistent in chasing up the local authority.
I think there's been a follow-up to that question saying the council won't serve an improvement notice because they like to deal informally, even though the roof was a death trap. So
this is something when the law changed. Hang on, when was it? Because there was a lot of debate about what. Oh yeah, I remember when this thing about disrepair and improvement notice in Section 21 came in. The question was, what do you do if the local authority is failing to pick up the phone or failing to serve a notice? Because if they deal with it informally, that's no good. You won't be able to challenge the Section 21 notice. So what you would literally have to do is go for judicial review proceedings and take the council to court and say you have been presented with circumstances in which you should be serving an improvement notice, and you're not doing it. And as a result of that, this person not only faces living in unsuitable conditions, but also faces eviction. It may be that actually if you went to the if you went to and made a homelessness application and asked them to help you to avoid the loss of your home, the people in the housing department dealing with that might get onto their colleagues and say, can we serve an improvement notice, which would have the effect. But it is really difficult. And I've had that before where they say, well, we just write to them this time. And you think, well, that's no good. So yeah, it's a problem.
It sounds like the sort of situation where the LGSO would get involved. Like I need to, it's not, as I say, not something I've dealt with much before, but I'm pretty sure it comes within their remit. And again, it sounds as though, so if the council is simply refusing to really go through the process, as Will says, you can, if you can get a solicitor, go get judicial review, great. But I also think it's potentially something that would essentially, you with a good, decent complaint involving councillors and all that sort of thing, using photos, all that sort of stuff. I mean, you might have seen a video on the channel with the lady in TA with the roof kind of collapsing in. Those kind of photos speak 1,000 words to councillors if they see that kind of stuff. So I'm not saying it's going to fix everything magically, but it might kind of help you out in that situation. So yeah, again, it's not actually going to help a person in this situation right now because the LGSO will take a year before you actually get the outcome from that. But it's something at least, I guess. And it would, making a decent complaint would open up that ability for the council to actually act better. So we done with that one. Lost my place now. Hold on. So next question, and I'm might do a bit of a cop out with this one. I know a couple who's currently about to be made homeless in a couple of weeks. They have 3 children, 2 of which are at university, and 1 that's 21 but still living with them. So they don't have priority needs. So there's a couple of parts to this. They'll be getting Section 189 relief duty. What does this mean? Will they get somewhere to stay, and will this be in the form of social housing or a hotel? And I think there might be a bit more down there. Hey, well, Andrew, nice to have you here, mate. They have been bidding on properties for almost a year. How long is the wait usually before they get to council house, and where will they be staying until they receive it? Okay, so good question. I don't have a lot of good news for you, unfortunately. So basically, if there is no, if no one in the family is in priority need, so whistle stop tour priority need, there are automatic characteristics like being pregnant or having dependent children, which dependent children doesn't apply here. You've also got the idea of vulnerability, which might be physical or mental health issues, disabilities, institutional backgrounds, but again, there's no mention of that here. So what you have is a family who is going to be homeless, but it may not be any reason to think they might be in priority need. What that means is Section 188, the interim duty to provide hotel or emergency or interim accommodation or whatever, is not going to kick in. And what that means is, whilst the relief duty will happen, it's going to be pretty toothless. And I know Will probably feels a bit differently and is a bit more optimistic than I am about this. But if the council is not going to have a duty to house you, there is very little motivation for them actually helping out in that relief duty. Although they have a duty to, take reasonable steps to support you into accommodation or words to that effect, they don't have to, and therefore they're unlikely to actually do it, given that they don't follow the law when they actually have to do stuff anyway. So there is a video on the channel I did a couple of months ago called "What If I'm Not in Priority Needs," which I talk about the relief duty in a bit more detail. And I'm not saying it's a complete waste of time, but on that information, there's nothing the council have to do. So, there's going to be no interim or temporary accommodation. Now, in terms of waiting times for bidding, it just depends on the council. If you're in London, 20 years, could be ridiculous like that. If you're in Bedford, which is where me and Shannon are, it ranges between like maybe 1 year and 3 years, 4 years or something, depending on the size of your household. So I don't think you can count on getting social housing anytime soon. And so what the council could do is, or in my opinion, what they're most likely to do is to maybe help with a deposit. So if you can find private rented accommodation where, it's affordable or whatever, then the council might potentially help you with that. So that's much more likely than them doing anything else in my experience. So that there's not a lot of good news from me. Guys, anything to add to that one at all?
All right, I will say about the new legislation, the reduction of homelessness. So try and put that in, that act that they're bringing in. So because effectively there'll be 5 people homeless here. So you can say.
Yeah. So, and I guess the other thing to say is that any one of those household members can apply in their name. If that, it doesn't sound like it's going to change anything in this situation, but that, yeah, there are situations where that might help out. But yeah, I just don't know that the council's gonna have to do anything basically. So
Isn't
yeah,
there something around young age and like an inability to deal with tenancies and being vulnerable with the ability to cope with homelessness because of actually you're young, you might be unexperienced, and so potentially applying, well, you wouldn't have to apply in their name, but that potentially could lead to a price and need. Not, it's going to be hard to sort of like have
yeah,
that argument, I guess, but it, and it depends on, again, I guess, why the 21-year-old is still at home, why they haven't gone to university. Is there something that's stopping them there? Are they working? Are they not working? Like all of these sort of life things
yeah,
could sort of come into play, I guess.
yeah. So young age is relevant. However, I think again in a situation like this, the council's entitled to look at the support that the young person is likely to get if they were homeless. So if you've got a 21-year-old person who has no support network at all, is kind of never managed a tenancy, then you begin to get into the ballpark of being vulnerable on that basis, although there's no kind of automatic cut point. So if you look at paragraph 8.40 of the Code of Guidance, there's some interesting stuff there. However, in this situation, what the council's probably going to do is say, well, you're a family unit, yes, the youngest people might be the most vulnerable, but they're going to have the parents kind of helping them out in that situation. So, I mean, it's going to be difficult, basically. I
And
think
they've just said, like, the 21-year-olds just finished university, they've moved back home, and they're looking for jobs. So they just want clarification that they will be, if they get completely kicked out, will they have to be living on the streets, or will they provide with anyone to stay? But if they don't fit priority need, then
yeah. So basically, if there's no priority need, the count, effectively they can be on the streets. That's the kind of way the law works, or it doesn't work. And I'm just going to add in that last bit in as well. Yeah, so I mean, basically in this situation, the council can provide some basic advice. Kind of, it's going to be generic probably, but really this family needs to be looking at private rented accommodation potentially, and once you find a landlord that's willing to take you, go back to the council and say, look, I've got this landlord, can you help me out? And if they're efficient, then they will be able to. Often councils, then the issue is lack of housing rather than necessarily lack of money. So some councils will be prepared to pay large amounts of money to help someone into accommodation. So engage with the relief period. Go for those meetings, sit down, make sure their personalised housing plan is thorough, challenge the council officer if they're just kind of using a template or something, and have those conversations and say, look, what we're going to do. But yeah, as crazy as it sounds, a family in this situation, they could end up on the streets. I hope it doesn't happen, obviously, but there's nothing in the law that prevents that happening. So yeah, okay. Where are we up to? Done that. If I miss anything, we'll try and pick anything else up. So next question. If a family has been evicted in priority need with children, can the housing officer refuse housing even if they can't find private affordable housing in the private sector? So no. So basically, if you're in priority need, the council is going to have a duty to house you. So let's go through the legal steps. So you make a homeless application by asking the council for help with housing and giving them reason to believe that you might be homeless. That triggers the application itself. And then if there's reason to believe that you might be homeless, might be eligible, which means having recourse to public funds roughly, and you might have a priority need, which a family with dependent children would be, then they have to provide interim accommodation, irrespective of whether or not they've got accommodation. So it's the council's problem, not yours, if you're homeless, to find that accommodation. They have duties to do it, therefore they just need to get on and do it, and they need to, turn every stone over to find it if they've got a duty to do it. And then once the inquiry process finishes and the council is satisfied that you are in fact homeless, eligible and in priority needs, then the council have either one of two duties. So either Section 190, which is what Will talked about at the beginning. So that's the duty to people in priority need but intentionally homeless. So the council still need to provide accommodation for a few more weeks. But most people won't be intentionally homeless in that situation, and therefore the council will owe the main housing duty. And a council cannot. I mean, I guess the councils can't legally do it. They can do it physically, but they can't legally do this and get away with it if you challenge them. So what I'd maybe kind of be saying is this family need to get the officer to put it in writing, and I doubt many housing officers would say that in writing. They might say it to your face, but they won't say it in writing because it's just not defendable, basically. And again, you know, if this person hasn't already, just get that complaints process up and running, make a subject access request to involve councillors. And in this situation, you're looking at not only your ward councillor, which is kind of covers your address, but you're potentially also looking at the councillors who oversee housing and oversee children's services, because they've all got some kind of interest in this case. You know, so that's, yeah. If I've read that question correctly, the council can't do that. That sounds like they're just acting unlawfully, and you just need to go through methodically, get them to put it in writing, and then complain. Either way, if they don't put it in writing, then complain and say they said this and they won't put it in writing. And if they do put it in writing, then even better. You've then got more kind of evidence of it being communicated. So, yeah. Anything to add to that one, guys? There's a long question here. I'm just going to try and get the gist of it.
I've been studying it a bit while you were looking at the last one. If you need any help with that one.
Yeah, no, please do, Will. So tell me what the gist of it is now. I'll try.
Well, I think the gist of it is that the person referred to they've accepted a duty to house them, and then they've offered accommodation 5.5 hours outside the borough, which is considered to be unsuitable, and that's the problem. And I think the question, forgive me if I'm misinterpreting it, is what can be done about this. And the answer would be, in my opinion, to try and challenge the suitability of the offer, which is something we've talked about before. I mean, there are many reasons. I mean, local authorities do get away with housing people miles outside the borough, but there are lots of reasons why they should house you near to the borough. For instance, if you're working in the borough, or if you've got children who have exams or the need to be at school, or you've got specific care needs which can only be addressed in the borough, those sorts of things. So you can challenge it, but they will try often to do exactly what's happened here because of the shortage of housing, to just say, especially in London, it's very common to say, you're never going to be able to afford somewhere in this borough because your benefits are capped, and we're just going to offer you somewhere miles away. So it does happen, unfortunately, but you can challenge it. It's quite difficult, but you can do it.
And that's definitely one more to get a solicitor involved. You can also have a look on the council. If you Google, the council will have a policy which is like, it might be called something different, but it's like an out of area placement policy or something. Now, it's something I'm kind of looking into at the moment for Bedford, because every council should have a policy which basically says, if we have to house someone outside the area, these are the things we'll do. And we've talked before about the case YRV Lambeth, if you want to Google that and have a look at it, where Lambeth itself had a policy which said we're not going to house people more than 30 minutes away from the kind of parish boundary. And that, that was kind of part of the reason that Lambeth lost that argument. So have a look for that policy. And again, I guess as horrible as this sounds, the textbook advice in this situation, or not that we give advice, is to accept the accommodation and then challenge the suitability of it. Otherwise, you're playing chicken with the local authority. And if you lose the argument, there is literally, you have no accommodation at all. So, yeah, I hope we've understood that. But yeah, so the legal answer is you can, for a lawyer, I think it's much easier to challenge a suitability argument because it's about how the council made that decision. Did they actually correctly assess, can the evidence that they correctly assessed every household member's needs, which they probably won't be able to do because most housing officers don't do that stuff properly. But for a layperson, it's a difficult argument to win. So if you Google Will Flack Law, you'll get Will's website, which has got a page which is like legal aid funded housing solicitors, and many of them will be at capacity, but give them a try. See if you can find one that's actually going to be able to take you on, because I think that's a difficult one. It does seem to me on the face of it that is an unsuitable offer, but that's just me saying it, and I'm on YouTube. What, it doesn't make a difference to your situation. You need to get a solicitor involved to actually go through the detail of it, I think. So cool. Yeah, just that person, that the one we did before where we couldn't actually see the question. I still can't see a question yet. So if you want to if you want to reiterate a question, that'd be helpful for us. So next question that I can see is, and Will, Shannon and Karis, if you need to go, we've hit 8:30, so feel free if you've got.
I'm okay to stick around for a while.
Okay, cool. Well, yeah, as I say, don't stand on ceremony. Just head off if you need to. So, question 11: is it possible to change housing officer if one is assigned doesn't seem interested? Oh man, yeah, common problem. You can in some situations do it. So, for example, I think it just talks about it for a domestic abuse point of view. But basically, if domestic abuse is involved, then you can request an officer of the same sex. I'm not sure if you can for other situations though, so that may not be no help at all. Unfortunately, in my experience, when you ask for a change in housing officer, they won't give you one. It's very, very, they just almost kind of see that as like, okay, well, yeah, if we keep the same housing officer, they're more likely to give up. So there's nothing that I know of that you can basically make them give you. You can ask for a different officer, but it's difficult, I think, really to kind of get them to. You can't make them change it basically. So yeah, I think that's again, and also just chip in with that one. Feel free. Okay, so we've got a question that's come through from the previous situation. What question was it? Oh, yeah, we didn't actually put it in because it was just kind of, I think it was just quoting stuff. So someone has secure tenancy, fled because of violence, mental health and pregnant wife, council accepted main duty, not want to give a secure housing or transfer the secure tenancy, any option to challenge. I don't think there is, but again, I might be wrong about that. So one of the many problems of domestic abuse is that people, if they go through this process, they will potentially lose that secure tenancy. So I think when we talk about secure tenancy, we talk about social housing. It's my kind of interpretation of that. But there's no kind of automatic protection on, an offer of social housing coming out of that situation. So they can offer you private rented. There are options around, there are on paper, there are options, I think, around management transfers and stuff. But in my experience, I've never seen that actually happen. They talk about it, but I've never actually seen a management transfer take place. But I think, it may be something a solicitor would be able to do a better job challenging.
Could I just say, I have seen management transfers take place, and where there is a genuine threat of violence, then you will get past the threshold. The thing I would say in this type of case, and I can see why, I've had cases where people have got a council tenancy and they don't want to lose it. But I've had to say to them, well, you're probably going to have to take private. But in this type of case, what you can try and do is say, you've got a duty to carry out an assessment of my housing needs. We're back to section 189A, and they have to carry out an assessment of your housing needs, which includes how you became homeless, what would be suitable accommodation for you, and what support you need. And that's important in framing how they discharge the duty and make you an offer. And one of the things they could think about in what would be suitable accommodation for you and what they could do to help you is whether they could assist you in pursuing a management transfer. Because obviously a council property might be an option for you rather than private. And you could challenge them if they haven't put that in your personal housing plan. I hope that makes sense, but they should basically, what they should be doing is sitting down with you and saying, okay, how can we help you? And a bit like us now, and they should be saying, oh, well, hang on a minute. the allocation policy says that if you're a tenant and you're fleeing because of violence, you can get a management transfer. So let's see what, and they normally have something like the management transfer panel or something like that. And so we'll nominate you to the panel and see what they say. And if they refuse to do that, you could definitely legally challenge it. Hope that helped. That's
You might have just said this, Will, but a lot of housing allocation schemes give the highest banding to people who've had to flee because of domestic abuse. So in many councils, you get higher banding than even those who are owed the main housing duty, which again doesn't guarantee that you're going to get social housing, but it increases the chance. Got a multiple part one here. Make sure I don't miss this off. Bear with me. So what we basically got here is we've got someone who's got some significant issues and they've just been told they're not in priority needs. So we'll try and unpack it. So question is, what is the threshold for vulnerability on PIP and limit capability for work? So so friends on PIP, limited capability for work, whatever those other acronyms stand for, I can't remember. Relief duty ended. Now the appeal with RMG, is that council? Or finding not in priority need or something medical. I'm not sure what RMG stands for. Although you're being awarded PIP benefit for daily living element, blah, blah, this does not make you in priority needs. Under section 189(1), which is the kind of the definition of priority needs, not being in employment or receiving particular welfare benefits does not make a person vulnerable. So, okay, so basically what, let's just start with the basics. In my experience, it's highly likely that someone on PIP and receiving limit capability for work will be in priority need. However, the group of people in that situation are they're the easiest people to gatekeep. Gatekeep's not technically applying here, but they're the easiest people to give a perverse decision and get away with it. So I would say what we're talking about here is someone who is actually in priority needs, but it's just a perverse non-priority decision. And I guess some things to say. So being on PIP or getting limited capability for work does not in itself mean that you're vulnerable. That's not the way the test works. It did briefly work for that in 2017, but it doesn't do that anymore. What you effectively need to do is it's about breaking down, okay, what are the difficulties you've got and what's likely to happen to those difficulties if you were to become homeless or if you were to remain homeless, and what harm is going to result from that. That's really the test of vulnerability. And as I say, most people on PIP, I mean, there aren't many disabilities which are going to get, not going to be affected by being homeless, whether it's physical or mental health issues, it's going to be affected by it. But in this situation, you need to get a lawyer or you need to get a decent advocate because you'll need to challenge a council kind of robustly. There's a lot of councils that do this. They just get away with these kind of nonsense decisions. Sounds like they're using a template, really. That's sort of template kind of thing that we see elsewhere. But that's kind of the situation. So, I mean, in terms of from a YouTube point of view, what can we do? Well, if you look on the channel, there's a couple of videos specifically about vulnerability. So there's one which is called A Judge Explains Priority Need or something like that. So if you search for the term judge on the channel, you'll find that video. Sarah Steinhardt talking about the kind of definition of vulnerability. There's a couple of videos that me and Will did looking at vulnerability case law, which we'll go into a bit more detail. But in reality, I'd say this person needs to get in touch with a decent advocate. I mean, if they want to just say privately or kind of if they put a message on a comment on a different YouTube video on this channel, just say what area they're from. We might be able to look at if we know of any services in that area, because I guess it's going to depend on geography as well if you get lucky with a decent service. So that's, I think, what I'd say about this. Again, if you guys want to just add into that at all, Shannon.
Yeah, so I guess it's just, and not everyone will have a copy of it, but you can request a copy of it from the DWP. With regards to PIP, when you get assessed and you've gone through the assessment and you've got awarded PIP, they'll not just send you a letter with how much you'll get and when and what have you. They'll also send you their actual assessment, which will have sort of like the assessor's comments about why they've given you certain points in certain areas. So that's a really handy bit of evidence, because that's almost literally saying, now, granted, it might not have anything to do with your housing, but it might have, you know, actually this person can't do such and such because of this, and this affects their daily living in this way. So I'd recommend, if you don't have a copy of that, requesting a copy of it. You can do that either informally, which again, I have found that to be quite effective with the PIP department, or you can sort of exercise your rights under data protection and do a subject access request and request it that way. And again, with sort of, that's the strongest route, to be honest. PIP over the limited capability for work and work related activity. Again, with that, you'd have had to have done an assessment. Normally there's like a booklet that you fill in with lots of questions. So if you have a copy of that, I'd recommend giving that to them. Again, that's something you can request from the job centre. It is going to be, I think, potentially the weaker one, but you can request the assessment. Normally that's awarded for like a set amount of time as well. So that might just give an indication of sort of the severity of disabilities potentially. And again, talk to you won't have a work coach, but you can write in your journal and sort of say, look, this is what's happening with my housing. Is there anything you guys can do? Because this is going to make my disabilities worse. Again, I'm not 100% sure on this, but the PIP helplines there, they're probably going to be less useful than sort of universal credit, but it's still worth a shot. I've rambled. Have I made sense?
That's cool. It's all good. Yeah, I think in that situation you just try everything, don't you? Because there is nothing else. It's a difficult situation for people to be in, and you're effectively relying on just finding someone out there who knows what they're doing a little bit and can provide that sort of supporting evidence. So there's just a follow-on comment. Just so the family we talked about earlier, where there was no obvious kind of priority need that we could see. They kind of talked about their local website. Their local council's website says that they won't let anyone stay homeless or sleep rough. What does that mean? Well, it doesn't necessarily, you know, some councils are good at dealing with homelessness. You know, they will go outside their legal duties and they will house people. So all the more reason to kind of, you know, as we said earlier, kind of engage with the relief duty and see what can be offered. But I would say something they've said on the website falls short of, you know, actually being kind of, you know, a kind of legally binding thing. And what that probably means, based on the sort of areas I know of, when they say we won't let people sleep rough, what they mean is they've got a street outreach team who'll come and verify you and try and get you off the streets. But you know, as an example, in Bedford, what that means is a room with camp beds on the floor, and you're expected to sleep on the camp beds. That's, you know, that's what, yeah, they're not. There's not like decent. It's not accommodation that anyone would stay in, and many people don't stay in it, and then they get told they've chosen to be homeless or whatever. So yeah, so I mean, certainly engage with councillors, engage with your politicians, engage with the relief duty process, but you know, from a legal point of view, there is no duty that the council has to put a decent roof over your head. And that's you know, maybe I'm wrong, or maybe Leicester will pull out all stops and do a great job, but I don't know that they will. So yeah, next we've got here a question about bailiffs. So they're basically been told to stay until the bailiffs come. Rather than go into it in detail here, there's a pretty comprehensive video on the channel called something about bailiffs. I can't remember, section 21's bailiffs or something. If you search for the term bailiffs on the channel, you'll get a video which I go through LGO decisions and stuff about it, and some steps about what you'd actually want to do. So because ultimately your main thing you need to do there is complain. Just complain now, not wait around for it, and just get that complaint process started. Question here about suitability of accommodation and kind of the private sector. So someone's, I think in the context of what they're saying, I think they're saying they don't find private rented accommodation suitable, mainly because it's only for short-term contracts and they want more stable accommodation to achieve more independence in day-to-day life. Sadly, in Britain in 2024 or whatever, we have a private rented sector which is rubbish, you know, in terms of the security of tenure, and that's just what there is. So again, the fact that you don't want to have private rented accommodation is not in itself going to be an argument that you need to be in social housing. As I say, yeah, as you're right, this person's right. It's far from ideal in terms of it's just not good for people to have kind of a 6-month, you know, contract and kind of, you know, not know what's going on. But that is what we have at the moment. So there's no kind of way around that, I don't think.
So that's slightly because and I know it's personal data and stuff, but there's obviously a disability there. Potentially requires like physical adaptations to property. So it might be worth getting an occupational health assessment done. You might not need adaptation to the property like at all, because I know there's sort of different levels. But that could affect like what type of housing you get put into if major adaptations are needed, for example. Not that they all necessarily have to be.
Yeah. Okay, so time's running away with this again, guys. If you need to head off, feel free to. So I think we're going to have to draw a line under the questions that are in the chat at the moment. There's still some questions that are coming through the week that we'll have to deal with as well. So this is a question that relates back to, I think, the whole, the kind of the offer of accommodation 5.5 hours away. So again, feel free to help me out, guys, because I can't quite get what the question is there. That they're kind of giving some more information about where they were and stuff, and they had local connection. So yeah, the problem we've got is, since the Localism Act, you might well have local connection to an area, but that doesn't mean to say the ultimate offer of accommodation won't be a long way outside the area. So it's not, in one sense, it's just, you're kind of down, you're knackered either way, really, particularly if you're in London. So yeah, I'm gonna scoot over that one, because again, I'm sorry, there's also a lot of personal data in it, so I'm just gonna, again, I'm not trying to be horrible here. I'm just keeping personal data out of the chat just for various other reasons. And there's just kind of talk there about falsification of documents. Councils do falsify documents, absolutely. It's very difficult to prove it. And so yeah, you just kind of often have to just work around the council's dishonesty sometimes. There's nothing, often nothing you can do about it. So yeah, just a follow-on questions. Yeah, sorry, it's a bit higgledy-piggledy this week. It's all right. So yeah, for someone who is on the housing register and they've been bidding on a property, if they then get private rented accommodation, which will almost certainly be deemed to be suitable, it most probably will have a kind of a knock-on effect to the housing register. So you kind of have a requirement to update the council if your circumstances change. So if you're band B and you've been bidding there, and then you get private rented accommodation, that may well mean that you get reassessed either as like the lowest band, or potentially just get kicked off the housing register altogether. And so it can have that that kind of that knock-on effect on your bidding. So some people in that situation would basically try and move in with extended family for a period of time, so they can continue bidding and hope that it kind of works out. Again, you want to just make sure that you're kind of having those discussions whilst in that relief duty, making a personalised housing plan and so on. So just a real quick return to the disrepair questions we had earlier. I'm going to put this back over there. So where's it gone? Here we go. So can a landlord be sued for disrepair and get rent payback even if the tenant was in receipt of housing benefit? My understanding is yes, but again, Will, you answered it earlier. So would so let's say housing benefit was covering all the rent, would that still be kind of paid as compensation to the tenant?
In terms of a disrepair claim, it's not the same. There is a thing called a rent repayment order, which I don't know enough about to talk about. But in terms of a disrepair claim, you wouldn't necessarily be making an application for your rent to be paid back, but you'd be asking for compensation, which would be calculated with reference to how much rent you paid. Like I said before, you work out a percentage of what the rent is and claim that back. So you could still do that even if you were in receipt of housing benefits. I'd have to check out. I think rent repayment orders is where people are found to have breached certain rules, and the council can order them to repay the rent. But that's slightly different from just a plain disrepair case. I could look into that and answer it another time.
Yeah. Okay. So I'm just multitasking this. Again, there's a lot of personal data going here. I've just removed a bunch of it, guys. As I said at the beginning, this works far better if people don't put personal data into the chat or anywhere, basically. What have I just done there? So bear with me. Nearly there. Cool. Right.
Somebody
Right,
see
I'm
if
going to
we
just.
should-
I'm just going to switch.
Stress.
Sorry, Will. Yeah, go for it.
Somebody said, please answer my question asked on the video of your channel about
Yeah.
developing PTSD in the YMCA.
That's on the list from the week. So let's switch over to the ones we had in through the week and just kind of tidy up anything else on the live stream. So as I say, we're going to draw a line under the live stream for the time being, but we'll try and pick anything else up that's come through. So, where has that question gone? I did see it this week. Oh, here we are. So, yeah, here we are. Sorry, I should have put this on the beginning because it's anonymized. So, Fred moved to a different area for support accommodation. Joined the register and was given only one reasonable preference band E due to no local connection. Since being in the YMCA, she's been diagnosed with PTSD. In contact mental health team for treatment for this. Could she be reassessed by the council as having a priority need in place in another temporary accommodation due to the severe impact of current accommodation is having on her mental health? So, the kind of devil's in the detail here. So it depends on the license agreement of the YMCA that she's staying in. Ordinarily, with supported accommodation, you're not legally homeless whilst you're there, and so things like priority need don't kick in. You haven't, once that you haven't made a homeless application at that stage. However, there is a rather complicated argument to make that you can make, where someone with severe PTSD, it might well apply to them. So that would almost certainly be a disability. You've got two ways of approaching it. One is to argue that the severe PTSD is a disability and the current accommodation is making it get much worse, and that would need to be evidenced by a psychiatrist or kind of treating professionals or whatever. If you can get that level of detail in the evidence, and it's a high threshold to cross this one, then yeah, you could then you might then be considered to be legally homeless, and therefore priority need will kick in, and yeah, you need to be moved to a different temporary accommodation. But just to make the point, ordinarily YMCA type accommodation is not the same thing as what we talk about in this live stream about temporary accommodation. So when we use that term temporary accommodation here, we're talking about accommodation that the council has provided under section 108 or under section 190 or section 193. Ordinarily, I'm sure there's going to be exceptions to this. Ordinarily, YMCA accommodation would not meet that definition. It's something else. It's not a statutory thing, as for ordinarily, and therefore you kind of trapped. That's one of the reasons why we've talked against supported accommodation before, because you don't realize it when you sign up to those licenses, but you effectively cut yourself off from the options that you might otherwise have. Another option would be for the YMCA to issue an eviction notice and say, it's not anything this person's done, it's just this isn't suitable for them because of their mental health issues. And therefore, so you're not intentionally homeless. You then make a homeless application based on that. It's highly likely this person would be in priority needs, and therefore they would then get, they kind of go through the homelessness process and they'd get an offer of what should be suitable interim and temporary accommodation. So, and I think, and we, in terms of local connection, if this person's been in that YMCA for 6 months, then they would have local connection. No, tell a lie, because that's, again, it's the Part 7 definition, so ignore what I just said there. One of the difficulties is that local connection is different under the housing register definition and the homeless application definition, just to confuse everyone as much as they possibly, as the system can. But I think that would be the two options I can think of that would be open to this person. But it's going to require a very helpful psychiatrist to be willing to actually write a detailed letter, and they need to focus very sharply on whether this person has a disability. The answer is probably yes. And is it the accommodation which is making it get much worse? It may well be, but you need to get a psychiatrist or someone saying that. So that's my answer. Again, anyone want to add to that at all?
Could I quickly add to that? Say I have been doing quite a lot of work on this very subject, including the YMCA and post-traumatic stress, and it has been quite productive. That it's post-traumatic stress is one of those conditions that is only sort of coming into focus. You know, it's like after the Second World War or the First World War, there were loads of people that came back traumatized, but nobody diagnosed it. After Vietnam, it started becoming recognized. And nowadays it's becoming recognized as something that you don't have to go to war to get. So somebody that's been in prison, for instance, may well be suffering from post-traumatic stress because of things that have happened in there. I've had cases where somebody who was in shared accommodation that had had bad experiences in prison and was diagnosed with post-traumatic stress was held to be vulnerable and also couldn't be put in, had to be in self-contained accommodation. And I just had somebody who was in the YMCA, who was found to be suffering from severe post-traumatic stress, and the council accepted that he should be provided with alternative self-contained accommodation. But it does turn on psychiatrists, because I had the same psychiatrist for one client said he hasn't got any post-traumatic stress, and I thought, oh dear, this guy's too battle hardened. You have to be sort of cracking up before he recognises it. But then I got the next one back from him 2 weeks later, which said, yes, this person is very traumatized and is disabled and, all the things. So the answer to the question is yes, I'm not talking about the preference band, but I am answering that the question is that they could be assessed as being in priority need and then placed in different accommodation, which would need to be suitable. And suitable here would be self-contained accommodation, which would get you a long way from being in the YMCA. I hope that helps.
Yeah, hopefully it does. Yeah, I mean, it's a difficult one.
Yeah.
Again, if that person wants to just put a comment on a different video on the channel, to say what area they're in, and maybe we could point you in the direction of someone who can kind of help you out with that, because you're going to need a solicitor, really. I think it's probably what is in reality. Cool. Right. So, what questions we got left? Done that one.
Oh. Do you take donations?
Yeah, for the person saying do you take donations, thanks very much, but not really, no. But if you want to just like the video, subscribe to the channel, share videos, that sort of thing, it helps us out. So
and we do training.
Oh yeah, we do, yeah, training as well.
So
yeah, I mean,
if you want to get something for your money.
Yeah. If you want to come and training yourself, it's 30 quid if you're not working for a professional organisation. Number 16, regarding Section 108 accommodation, the council has sent me a reminder 2-letter saying to provide evidence, basically for mental health. I'm rough sleeping. Should I complain? I'm in the process of getting supporting letters. Also, should I send them the supporting letters or wait until they end relief duty, then challenge it? So my priority decision is made by someone else. Interesting question. So I think the answer is there's a bit of a trick to this, actually. So and it's interesting that the council sent a minded 2 letter at this stage, because they don't have to have done that. It can be a bit of a trap, but this is going to get complicated. The trap is that what they've said is, we think you're not in priority need. You then send them all the evidence that you've sent them, and then they go on and make a perverse non-priority decision. The problem you've then got is to challenge it in a good way. You've already kind of submitted all the evidence, so you can't really then ask to be accommodated whilst they then look at the review request. So I'm not quite sure. So as someone, if it was me supporting someone in a situation, because I've done it before, I kind of have a bit of experience with this, I would send pretty much everything to the council now, but I might almost like hold one thing back that I could then use down the line to kind of show that there's new evidence and kind of give some more options. I know Will's probably going to say that it's the council's job to make these inquiries anyway, which is true. But if you've got that supporting evidence, oh man, I don't know. If it was me, and
a tricky one to get right, isn't
it? Yeah, I mean, if it was me supporting someone in this situation, and as I say, I've done it lots of times before, I would potentially send it now, but just make sure it's couched in the right terminology, because it's not about your diagnoses, it's about how your issues will be affected by being homeless, which is a different thing. And it's an area where councils just routinely issue perverse non-priority decisions. So Again, I guess what we'd say is, if you can find an advocate or a supporting agency who knows what they're doing, then try and find one to help you out with this. There'll be an argument to say don't send it, and just when they issue a non-priority decision, then provide it and kind of as part of the review process, because you're then in a stronger position. Shannon?
I'm probably being slow because it's gone 9 now, but so the person said they're rough sleeping. So I'm going to assume that they haven't been given interim accommodation at all, even though the council's had reason to believe, because they must have reason to believe if they've sent a minded to letter. So could the person complain and request interim accommodation on the basis that the council have reason to believe that they might have a priority need, because they've sent a minded to letter asking for evidence, and they wouldn't do that? Do you see what I mean? So again, it's not like
Really good point.
complaining, but it get them into accommodation for the time being. And typically, not all the time, in fairness, and particularly maybe not with this case, but once you're in interim accommodation, it is sort of harder for them to kick you out. Not all the time, but yeah, am I reading that right? If they're currently rough sleeping,
it's a really good point. Yeah, if this person is currently rough sleeping and therefore hasn't been offered interim accommodation, but the council's then issuing a minded to letter that they're not in priority need, one of the options is the council just doesn't know what they're doing, and actually would be quite easy to challenge if you had to know how to do it. So yeah,
like chief exec time, sort of like write a letter straight to the chief exec explaining what we've just said, and like so it's not a complaint. But
if you've got a lawyer, it's judicial review time as well.
Yeah, it's a big. Sorry, Will.
I get so angry with councils, with people with. I mean, I'm not saying that everyone with mental health problems is sort of incapacitated and can't make representations, but you shouldn't have to provide evidence. They've got a duty to make inquiries, and what they should be doing is saying, yeah, well, okay, so you go in there, you say, I've got mental health problems. I think they're serious enough that I'm vulnerable. They say, okay, we've now got reason to believe you're vulnerable. We'll put you in temporary accommodation, and we'll interview you, and we'll sympathetically, and then we'll write to the necessary people. Because another problem is if you're sleeping rough and you've got mental health problems, you may not be able to get evidence. I mean, a lot of GPs say, oh no, we're not writing, we've told you before, we're not doing housing support letters. Whereas if the council write and say, could you tell us about this person, they might get something more. But I mean, it's the wrong way around. And so but on the other hand, if you've got evidence, I mean, if you've got reports and things, I mean, I would never advise somebody to sort of sit on them. And I mean, you might want to keep one up your sleeve, I guess, tactically, but you should be seen to be giving the stuff to them. And because it does make it harder for them to say they haven't got reason to believe.
Yeah.
So I hope that helps.
Yeah. It just underlines the difficulty there is, whilst you're rough sleeping, to try and pull all this stuff together and fight a council that's just acting perversely.
Yeah.
So good luck to that person, basically. I mean, again, there's some more videos on the channel which might give you a better understanding of what that definition is and what you need to focus on. There's also a video on the channel which is like how to challenge a non-priority decision or something, which again I kind of talk about some of the kind of template ways that council's trying to approach it. So next question. When challenging suitability, how could I win? The property they gave me, toilet dirty, water pressure low, can't see the door out from the window, no door, ring bell, also kitchen tilt old, gas hob oven above dirty. So, okay, I'm going to sound like really negative about this one. Most of those issues would be possible for the person to sort out themselves. And I appreciate when you're homeless, you don't have a Hoover and you don't have, kind of a carpet cleaner, but those kind of issues, so toilet's dirty, hob's dirty, okay, it is going to be a case of kind of making the best you can with it. Now, in terms of the only thing I'd say there's any kind of substance to it all, there would be the safety issue. Let's say this is someone who is fleeing a high risk perpetrator of domestic abuse, and they need to have some kind of way of checking who's knocking on their door. Then potentially you could raise that as an issue. And again, councils can put other measures in place, to kind of help out with that. but again, and unless like the water pressure low, unless things aren't working, so unless if the shower's not working or the hot water's not working or something, then yeah, that becomes more of a real issue. But certainly most of those issues would not be something that is going to win a suitability review. It has to be more than that. Basically, it has to be kind of unsafe or kind of, as we talked about earlier, kind of, hazards and stuff like that. So I don't think that's going to get very far, unfortunately. When I worked for Just Us in Bedford, we had a carpet cleaner. So when people moved into TA, we would often go in with them and kind of, help them clean it. Because as I say, you don't have a Hoover when you're homeless. You don't have often, you even have a broom and a dustpan and brush necessarily. And kind of also charities can provide those kind of items to help people out in that situation. And I think, again, I don't know how helpful this is. We even did kind of like Christmas appeals where we'd get people to donate, cleaning cloths and all that sort of stuff. So people would have a pack of cleaning stuff to move in with to their property with. So if you work for a charity, consider that kind of thing and having that stuff available to help people kind of deal with those kind of issues. So I'm flying through things as I can now because I appreciate time is running away with us. Incidentally, as you can see, we are very much kind of pushing this structure to the limit. So between us four, we're going to talk about, I don't know, options about increasing the number of live streams we do. Maybe we'll do one of Will's or something like that. So do bear with us. It's a kind of the format is creaking a little bit tonight. So next person got physical disability, unable to walk more than 20 meters, struggle with stairs, in and out bath, that sort of stuff. Having formal carers who help do my cooking, got depression and also an injection I take fortnightly to suppress immune system. I'm having issues with the council regarding if I'm in priority need, even though I've medical evidence and been diagnosed. I'll be homeless on Sunday. Would the council have to provide me with emergency accommodation, even though they do not haven't reached a decision? So the answer is legally, absolutely. This person, that there is absolutely reason to believe that this person might be in priority needs, 100%. The council will need to carry out inquiries to work out if there is. As we said earlier, there is no diagnosis which automatically means you're in priority need. It is about looking at how your issues will be affected by homelessness. But no council can legally say that there's not reasons to believe this person might be in priority needs. Expect them to bring in the fact that you've got informal carers and say, well, you must be fine then. That isn't the case either. The question is, if you were to be homeless, if you were to be street homeless, what would happen to your issues, your health issues? And the answer is, for somebody who can't walk 20 meters, they're going to get a lot worse. Therefore, they're in priority needs. But again, the council may try and make a perverse, stupid decision that you say you're not in priority needs. But the legal threshold is really, really low to provide interim accommodation. So no housing officer with an ounce of integrity can make that kind of decision and say that you're not. There's no reason to think you might be in priority need. So just hang in there, and again, check out that video I did about the best way to make a homeless application, because part of that is including those councillors, including those politicians, as a way of increasing the accountability on a council which is going to try and say this person's not in priority need. And then the final question we've got, again, is a pretty quick one. And just to say, Andrew, you put something in there saying that, can you answer the question from last week? I can't see a question. So Andrew, if you could very quickly put that into the live chat, I'll try and get to it. I can't quite figure out which question you're referring to there. So council offered me a shared house bedroom in the private sector. I accepted the offer. They did not ask to sign any tenancy agreement. It is available for 6 months under section 189B2, which I think is the final accommodation offer, maybe. Or it might just be the kind of informal offer. Who pays the rent? Universal Credit or council? I live in this property that offered me from May until now. Landlord says you owe me from June, July, August. Council paid to him for May. Council say Universal Credit has to pay. Universal Credit says council has to pay. What will happen if I leave the property because I don't like it? So on that information, Universal Credit needs to pay. And so this person needs to apply to Universal Credit for the housing element to pay the rent. The fact the council doesn't appear to have told the person this and kind of left them in some ambiguity might be a way of kind of going back and kind of complaining to the council to try and help out. But yeah, ultimately, I think it's going to be a case of trying to get it sorted out with the landlord. Again, I think going back to the council would help out as well, because at this rate, you're going to be coming back to the council in a few months' time to make a fresh homeless application, which they want to avoid. So they might be helpful with that sort of stuff and get things sorted out. But you may well have to pay the arrears off yourself and kind of figure that stuff out as well. And then what would happen if I leave the property because I don't like it? Then you would be making yourself intentionally homeless if you were to make a fresh homeless application, except that there might be a defence around affordability. You know, if that was a good faith error, then maybe that might be in it. Yeah. But certainly leaving the property because you don't like it is not a good move. You know, you need to be approaching the council first. So that's my answer. Do you guys want to add to that? I appreciate I just rushed that horrifically, so I apologise for that.
Sorry,
Yeah, go
I
on,
will
Karis.
just say if you go to Citizens Advice, they'll help you make housing benefit applications and maximising your income applications, and they'll see what benefits you're entitled to. I think that would help in this because you'll become into a rent arrears, and they can help with that.
Yeah. And then there might also be other local kind of debt advice or money advice services as well. So obviously CAB has not got universal coverage, but something like that could help out.
Can I make two very quick comments on that one?
Yeah.
Comment number one is, and I know this sounds silly and it's the same comment I made before, but if you leave the place because you don't like it, you would be intentionally homeless unless the reason you don't like it is perhaps a reason that would make it's because it's unreasonable for you to occupy. For instance, if you don't like it because you're being chased by the mafia, then that's a good, you know, you're at risk of violence. But if it's just because the ashtray's full, then forget it. But the other thing I'd say is if you're in that situation and you've got a sympathetic landlord, get them to write a letter to you saying, I'm fed up with these rent arrears. I'm going to evict you if you don't get it sorted. Take that to the council and ask them for help in avoiding the loss of your home. And if you're lucky and you get somebody sympathetic or doing their job properly, you could get them to sort out the mess and get somebody to write to the DWP because they should be paying that. And also they could give you a discretionary housing payment to clear the arrears. So that's just my positive
cool.
on that.
Sounds good. Yeah. Right, final question we're going to do for tonight. Friend made a homeless application more than 6 months ago after receiving Section 21. He was interviewed by housing officer and he submitted supporting documents, letters from doctors and vulnerability assessment about his health and disability. After this, he's been totally ignored by the council, never receiving any communication to let him know if he's in priority need or not, nor any replies to his emails. Meanwhile, he received a claim for possession papers from court. So he submitted a defence to gain some time. While still waiting to hear something from the council and court, he found a solicitor willing to take his case and represent him because of the unlawful action of the council. But then received, there's a bit more, but then received notice from the court that the claim was struck out on a technicality. So the solicitor had to close the file on the case because they're not legally homeless at that point. Struth, it's still coming. The landlord has served a new Section 21 straight away. Does my friend have to start a fresh homeless application or can he still contest the old claim? I guess the first question is go back to that same solicitor because they can always open a new file, would be my initial thing. And in terms of kind of the council blanking him, just do a subject access request. That will wake them up a little bit because you then get kind of what consideration's been done. Yeah, I'm just making sure I've got all this. Hold on, guys. I missed a bit there. I feel like I missed a bit of it out. Oh no, I might be right. So yeah, subject access request that will give you access to the records. I don't think there needs to be a fresh homeless application unless the council has issued a not homeless decision. But that in one sense doesn't fix anything because the issue is the council not responding. So yeah, do you guys want to just, I haven't read that entirely properly. I just want to make sure I've not missed anything. Do you guys want to come in on that one at all?
Could I just say, I think in practical terms, you probably would have to make something approaching a fresh homeless application because the council are entitled to say, well, yeah, okay, we've looked at your original claim, but your landlord's claim for possession got struck out, so you're not at risk of, you're not homeless or at risk. But I would say that the bottom behind all of this is just this failure to engage with the applicant. So I would say do a Google search for the name of your council and complaints and that should get you to the complaints page on their website. And make a complaint via the website, because that does use. There are often dedicated staff who will pick those up. Whereas if you just write an email saying I want to complain, we do both actually, but go to the website and complain, and then somebody will probably pay attention to you. But you're definitely once the new notice is expired, you're entitled to be treated as homeless again, aren't you? If it's a valid Section 21 notice which is expired.
I was going to say it's been reserved, so would it not be more of a case of, rather than a fresh homeless application, but like updating the council on the person's situation and saying like, I mean,
it just
might affect the dates and.
I was saying it's sort of something in practice which is like a new homeless application, but you wouldn't have to sort of formally withdraw your application and then make a new one. But you'd say, "Oh, it's me again," sort of thing. I've got a new notice.
Yeah. Okay. Cool. Hopefully that kind of gives you something to kind of get on with anyway. Bit of an action way forward. We're going to call it a night for tonight, guys. We will then make an announcement soon about doing another one a week or something.
Definitely.
So just hold with us, and I'm sorry tonight's been a bit chaotic and difficult to kind of follow everything. But again, I hope this guys has been useful. We'll see you next week. So yeah, take it easy, guys. As I say, don't give up, keep going. Often just kind of challenging council can be enough to make all the difference, even if you don't exactly know what you're doing. And involving politicians again is going to be helping you out. So